Okay, welcome to today's verdict. I'm your host and trial attorney, David Lesh. We have a diverse show today, starting out with surveillance in the subway system. Moving on from that, we'll be discussing IVF treatments and with respect to a gay couple. And also, finally, we're going to be discussing solitary confinement in New York's prisons and whether it's fair or not fair. What are your thoughts? So as you can see, we have much to get to, so stay tuned. Today's verdict starts right now. Okay, welcome back to today's verdict. I'm your host and trial attorney, David Lesh. We have joining us today Jerome Greco, a digital forensic supervising attorney with the Legal Aid Society. We love the Legal Aid Society. They come on all the time. How you doing today, Jerome?
I'm good, thank you. Thank you for having me on.
It's our pleasure. So we're going to be talking a little bit today about surveillance and the subway system. But let's start from the basics. What's the law right now with respect to surveillance in the subway system?
As the law stands for in terms of what actually can be surveilled in the subway system, there's a lot that allows. There's a Second Circuit case called McWade versus Kelly that allows the NYPD to search bags for the purposes of preventing terrorism. And the Second Circuit said that met a special needs and wasn't in violation of the Fourth Amendment. However, you can't do that just for the purposes of standard crime investigation or law enforcement purposes. As we know, there's plenty of surveillance going on in the subway generally. Cameras are everywhere. Police are everywhere. But this upcoming suggested or proposed scanner system for weapons detection or gun detection, these electromagnetic weapons detection systems.
Well, what kind of what are we talking about? Like, explain to me what this system, because I'm not really understanding it. What is the system?
Well, so that's a good question. There's some part of the problem with that is they haven't told us what vendor specifically they're going to use, although they demonstrated one specifically named Evolve. But the vendors themselves are very vague in how exactly it works. And they although claim that they use some version of artificial intelligence to identify weapons that are hidden or obscured on people's bodies or in their bags. And there's some serious questions about the legitimacy of that, considering a lot of false positives in trials that other institutions have done, hospitals, schools. But essentially what they're claiming is that they can identify guns and knives that are on people's person or in their bags without having to search their bags separately or have them.
I mean, is that true? Can they do that? Is that technology exist?
They claim it does. I don't think it works anywhere near as well as they claim it does. So, for example, at Jacobi Hospital, they tried this system out and for a 7-month trial, and it had an 85% false positive rate, meaning 85% of the time they stopped somebody who did not have a weapon. There was a school in Utica, New York, where an officer who was there for a parents' night walked through with his gun on him, his issued law enforcement issued gun, and it didn't go off yet. And also a knife didn't go off, and a student was actually stabbed on a different occasion. There's been multiple reports of other places where 3-ring binders set it off.
Why a 3-ring binder or a laptop?
That's a good question. I can't understand how a system that supposedly can identify weapons on individuals or in their bags is falsely saying that a 3-ring binder or a laptop or umbrella is a weapon. And you can imagine the number of New Yorkers walking around with one of those items on them, especially going to and from work or school.
Well, let me ask you a question. Is the system being used right now, or do they want to use it?
It is not currently in place. They want to use it. So they proposed what we call an impact and use policy pursuant to a local law called the Post Act, which stands for the Public Oversight of Surveillance Technology. And required under the Post Act is that they are supposed to post the draft policy 90 days prior to the use of this of a new surveillance technology. And the first 45 days allows the public to comment on these policies in order to try to influence them. And then the NYPD has another 45 days to take into consideration those comments before issuing a final policy and potentially using that new system.
I think your argument is that it targets individuals of, black or brown color more so than any others.
So for essentially, it's not that the system itself targets black or brown people more often. It's that the NYPD is going to choose which subways to put this in, right? There's over 1,000 entrances to New York City subways. And so they obviously can't cover them all. So it's going to be up to the NYPD to choose which ones they want. And they have historically have significant issues of where they decide to put both surveillance and stop and frisk. And this would be just an extension of that. Additionally, we know that Black and brown New Yorkers are more likely to take public transportation than white New Yorkers. Indigent people are more likely to take public transportation than wealthy people. And so it's inherently going to pick them up more. And then, of course, if it goes off, then the interaction that people are going to have with the police historically has been worse for Black and brown New Yorkers. And so now you have an officer being told that there's potentially a gun or a knife on this individual, and we're expecting them to be very friendly and not cause an issue when we've seen how the NYPD reacts with that on a normal basis. And so I think that's where we're going to see the most likely disparate impact.
I was going to say, is there any kind of compromise that maybe legal aid has with respect to this type of technology?
I don't think we should use technology that doesn't work.
Okay.
And so I think that's a pretty fair thing to say. We really shouldn't be stopping people based upon a very faulty technology. Even the CEO of Evolve, prior to the NYPD's announcement, had told shareholders that he didn't think that it was a good system to be used in the subway. So even the leading company for this for possible use is saying it's not used. It shouldn't be used for this purpose.
Well, let me ask you a question then. So I don't mean to put you on the spot, but what percentage false positive would you accept? In other words, would you say fine, 10% false positive? I mean, is there a number that you would agree would be fair? In other words, if we're able to show the technology is better?
I don't know if there's a specific number, one to say that this technology works, but I know 85% is definitely not acceptable.
Not good.
And then you also have the secondary problem, which is that this is still an unlawful search. You can't just search people in the subway or public transportation in general for the purposes of general law enforcement, general crime prevention. And that's what the Second Circuit has said. That's, years of US Supreme Court case law has said. And so I think that you have a faulty technology, and it's also a constitutional violation.
Where do you think we're heading with this type of technology? Do you think we're going to be seeing much more of it, types of technology in all places besides the subway as well?
I think that is a concern that a lot of us have, and seems to be being proven true, that more and more, not only law enforcement, but private entities are relying on faulty surveillance technology. And the consequences, we see are people being harassed, being prevented from entering stores based on a faulty facial recognition match, or being held. And I think this is just another part of that. It's also another part of the Adams administration faulty adoption of technology, as we saw with the subway Times Square robot, which they've already abandoned because it was frankly useless, just a waste of money.
All right, well, Jerome, we're gonna have to stop there. Very interesting. Hopefully you can come back in the next couple of months and tell us how this technology is panning out.
Thank you. I would love to do that.
All right, stay with us. Today's Verdict has so much more coming up right after this. All right, welcome back to today's verdict. I'm your host and trial attorney David Lesh. We have joining us today Peter Romer-Friedman of the Peter Romer-Friedman Law Firm. Peter, how are you doing today?
I'm doing great. How are you?
So first of all, tell us a little bit about you. Who are you?
I actually grew up in Brooklyn, in Park Slope. Went to high school in New York. I went to Columbia Law School. And I've been practicing law for about 15 years. I was a labor counsel to Ted Kennedy on the Senate Labor Committee. And since 2009, I've been mostly working as a class action and impact civil rights litigator. I practice throughout the country, but I focus on New York and DC, where I'm a member of the bar. And I've worked in a lot of gay rights cases over the years, including the one that we filed last Thursday.
Let's talk about that particular
Yeah.
action. Tell the viewers about it.
Sure. So last Thursday, my clients, Corey Briskin and Nicholas Magipinto, they're a gay male couple, got married about 8 years ago. They filed a class action lawsuit against the city of New York, as well as Mayor Adams and former Mayor de Blasio, claiming that the city of New York, like all employers, that if they provide IVF benefits to their workers broadly, that they can't exclude gay men from receiving those IVF benefits. And that's essentially what this case is about. Corey and Nicholas have wanted to expand their family for a number of years. And Corey Briskin was an assistant district attorney in New York County as a prosecutor. Unlike the women and the men who were married to women down the hall from him who got IVF benefits from the city, Corey Briskin could not receive those benefits. And that has caused Corey and Nicholas to delay at least 5 years in growing their family biologically. Gay men, when they want to expand their families and have a biological child, really have no feasible option besides using in vitro fertilization. And unfortunately, while the city's health plan is very generous towards most people who want to get those benefits and grow their families biologically, gay men, we believe hundreds, if not thousands of them, have been denied that same equal opportunity.
All right, now the couple, have they always wanted a child, or is this something new, or when did they decide to put the process in motion?
Well, they've wanted to have a child since they were married in 2016. And in 2017, when Corey Briskin became a New York City employee, he was hopeful that the city would provide IVF benefits to them that would make it easier and less costly for them to grow their family. They have put that dream on hold from 2017 until 2023. Corey Briskin did end up leaving the city, although he's still on the city's health plan. But in 2023, they were able to get the resources to start the IVF process. And so now Corey and Nicholas have fertilized embryos. They were able to get an egg donor and paid out of pocket for the cost of the fertilization of those eggs. So this year, they are hopeful that they will have a surrogate who will carry the embryos and the pregnancy to term, and they'll have one or maybe even 2 kids this year. But like a lot of other gay men, it didn't come without a very significant price, a price that employees and their partners who are not gay men have not been asked to bear.
All right, well, it's a class action. So who's being represented in the class?
So the class is essentially all gay men who were denied or were rendered ineligible for getting IVF benefits through the city's healthcare plan over the past 3 or 4 years, actually 5 years for the employees. So we're representing both the employees and their partners who are gay men who have been denied these benefits. It's a very lengthy period of time because the New York City human rights law allows us to go back 3 years prior to the time that my clients filed their discrimination charge with the EEOC.
So are we filed in New York? Is this a federal filing?
It is. So we filed the case in the Southern District of New York in the U.S. District Court there in Manhattan. And we brought claims under the federal Title VII statute, Title VII of the Civil Rights Act, which prohibits both sex and sexual orientation discrimination in terms of the workplace, including when providing employee benefits. We also brought claims under the federal equal protection and due process clauses, as well as under the same clauses of the New York State Constitution. And then we also have claims under the New York State and city human rights laws, which prohibit sex and sexual orientation discrimination in the workplace.
So where are we in terms of discovery? Have you taken depositions on these types of cases? What's been going on?
Well, we haven't gone into discovery yet because we filed this class action lawsuit on last Thursday.
Okay.
So we've just served the complaint and the city is accepting service. We're not sure whether the city will and other defendants will move to dismiss or will answer. But we did have an opportunity to take some informal discovery when we filed the charge with the Equal Employment Opportunity Commission. And so, as you can see in the complaint, we've detailed a lot of information that is not publicly available because we obtained it through the EEOC process.
Have there been any settlement negotiations? Has anyone discussed, this is for pecuniary loss in some respects. Has anyone discussed any kind of monetary compensation here?
Well, we have reached out to the city to talk settlement in the past. Normally, settlement conversations are confidential, but I can tell you we have not received any sort of interest from the city in sitting down to talk about settlement, and I think that that's unfortunate because we've heard from the city council members who introduced a bill to provide these very benefits to Corey and Nicholas and other gay men, that city leaders don't stand by this policy. So the mayor in many ways is standing alone by defending this policy before the EEOC. And, we would hope that the mayor would work with us to settle this case. It would be a very easy settlement. We've said publicly what we're seeking, and that's what we would want in a settlement. We want a change in the policy so that gay men going forward would not be categorically excluded from getting IVF benefits through the city's health plan. But we also want compensation for the employees and their partners, like Nicholas and Corey, who have been denied these benefits in the past. And we can figure out the right compensation in a fairly straightforward way.
How would you do that? I'm actually curious. How do you know what the compensation is?
Well, at a minimum, the compensation is the out-of-pocket cost that Corey and Nicholas and the gay male employees of the city and their partners have expended. We could do that through estimating those costs and a claims process. What might be a little bit harder is compensating the people who didn't actually go forward with the IVF benefits because they couldn't front the costs. But we certainly could agree on an amount of money that would compensate those families, those couples, for being denied the benefits.
All right. Well, Peter, I want to thank you very much. I think it's a very interesting issue, and I'm sure the viewers appreciate you being here. Maybe you can come back in the next couple of months and let us know how the litigation's going, if it is going.
Happy to come back and talk about it. Also happy to talk about other cases that I have against the city of New York and other civil rights cases that are going on in New York City. These are important issues, and we hope that the federal courts here will give us some relief.
All right. All right. Well, thanks again. All right. Stay with us. Today's verdict has so much more coming up right after this.
Only 57% of New York City high school students are college ready by their senior year. "55% of high school graduates either have no plans to attend college or are uncertain that they will ever attend. "34% of young adults don't go to college because they can't afford it. Discover what's possible. BronxNet's education programs, internships, and opportunities help engage and inspire Bronx youth and beyond to pursue their passions. Be a part of the BronxNet family. Whether you're interested in our shows, joining a class, or donating to support our mission, visit bronxnet.org to learn more.
All right. Welcome back to today's verdict. I'm your host and trial attorney, David Lesh. We have joining us today, Anisah Sabur. Am I saying that the right way?
Correct.
Okay. Tell us a little bit about who you are.
So As you said, my name is Anisah Sabur. I'm a member of the Halt Solitary campaign in New York State. I'm a solitary survivor. I worked diligently with the campaign for over 8 years to reduce the use of solitary confinement in New York State prisons. And we just currently reduced the use of solitary confinement in New York City jails through council legislation.
Now, what was your experience?
So I was in solitary confinement in Rikers Island in 2000, between 2000 and 2003. And it was horrifying. It really was. It's my first experience being isolated, first experience being incarcerated, and not really even understanding why I was put in solitary confinement, because there was, to me, no real action that considered me being isolated away from the general population. I wasn't a danger to anyone or to myself. There was a verbal altercation that went on between me and another incarcerated person, but the next day, the person was released. We both lived in the same unit, and the next day we went to court, she was released. The next day when I came back from court, I had an extensive infraction saying that I disobeyed all of these rules. And I'm saying, why? For arguing with somebody? They gave me a 120-day sentence. I was in there for about 3 to 4 days before I even got a hearing to tell me how long I was going to be there. And I'm saying, why? Because there was no altercation, and there was no one being harmed. I didn't understand it.
No, yeah, and you ended up in solitary confinement.
Yes.
For how long?
61 of the 120 days that they gave me.
Did you ever ask to be taken out of solitary confinement?
It's a process. You have to write to the board in Rikers, the hearing board, and explain why you want to be taken out. It was like, I'm saying, like, who did I harm? Why am I in here? When I got the ticket, they gave me the ticket for fighting. It was never a physical altercation. But because we didn't stop arguing with each other when the officer told us to, that made us get what they call disobeying direct orders.
So let's talk a little bit about Local Law 42 to end solitary confinement. Talk to me about it.
It's the best thing that New York can do, for one thing, to save lives. So Local 42 will now end solitary in any form. Solitary is isolation. It's torture. It has killed people. But right now, the law says you cannot hold anybody in separation from general population for more than 4 hours. Give them time to de-escalate and address the behavior.
Well, what does New York City think of this? I mean, has it been implemented?
So it has been a back and forth about safety. And this bill and this law, excuse me, because it's a law now, will really save lives, right? It will help people to really think about the behavior, whether it's something violent or just whatever the behavior is. If it's people go to solitary for some minute stuff, substance use in the facilities, having too much of anything that they're not allowed, anything that's considered contraband can get you into isolation. But this law says instead of isolating someone, you separate them if there's a real altercation or real violent act, then you can then address that violence, right? You give them 4 hours to calm down, to talk about what happened, and then find alternative means to address the behavior.
What type of alternative means are you talking about?
So it can be for anything. So if there's a violent act, and I'm gonna go with that because this is what people are actually looking at. What happens when a violent situation occurs inside of our correctional settings, right? First thing they do is they isolate people. They leave you there for days at a time, right? No one to talk to, no one to address what just took place, right? By the time they come back to some people, and I need to say this, they're dead. They've used things in the past on Rikers Island which are actually shower cages, which is supposed to be used to wash somebody off after a chemical spray on them, right? But they leave them there, even after they wash them off, in this 2x4 of a cell. It's smaller than an actual shower. And they're gated in there and they're alone. So instead of doing that, you give them 4 hours to de-escalate, to think about what they did, and then address it. So there's programs that are being used across the country in different settings where violence has reduced to 0 in some facilities. And in these are facilities where the worst of the worst supposedly are there, right? But they're not using solitary as a method to address any behavioral harms. So there's something called the Merle Cooper program, right? Which actually addresses the behavior of violent acts.
When is this program being used?
It's not being used in New York, and this is what we want them to use in New York.
Okay.
So we're trying to adopt programming from across the country that is actually working to reduce the violence in facilities versus putting someone in isolation and leaving them there for decades.
Well, it's definitely a topic we could debate for a long time. Maybe you could come back on in the next couple of months and tell us what's going on with local law 42.
So hopefully in the next couple of weeks, we'll be having rulemaking hearings to actually get the department to begin to utilize the minimum standards of the rules in New York State and New York City that follows local law 42.
Okay, so we'll see you soon, and good luck, and thanks for giving us all this information.
Thank you so much for having us.
All right, you take care. Stay with us. Today's Verdict has so much more coming up right after this. Well, that's all we have for today. I'd like to thank our guests for joining us, and of course, you, the viewers, for watching. If you have a topic or an issue you'd like to see on a future edition of Today's Verdict, feel free to email me at davidlesh@bronxnet.org. Till the next time, know your issues, reach a verdict. I'll see you in 2 weeks.